and welcome back to the channel. If this is your first time here, you are welcome. Please remember to subscribe. If you are a returning viewer, thank you for staying with us. Now, today's discussion is one of the most controversial and often misunderstood issues in Nigerian criminal law. Can a man rape his wife? Can a husband rape his wife? Is the wife whose bride price he paid in the first place? Now, many people immediately respond, how can a man rape his own wife? Others insist, marriage does not remove a woman's right to consent. In this episode, we will not rely on emotions, religion, or personal opinion. We will examine the law as it stands in Nigeria. Please stay with me until the end of this video. What is rape under Nigerian law? Before discussing marriage, we must first understand what rape means under Nigerian law. Now, under Section 357 of the Criminal Code, applicably mainly in southern Nigeria, rape is defined as unlawful carnal knowledge of a woman or girl without her consent. The key word there is consent. Now, the essential elements are sexual intercourse, absence of consent, unlawfulness. Now, under the penal code applicable in northern Nigeria, rape is similarly defined as sexual intercourse with a woman without her consent, or with consent obtained through force, threat, intimidation, deceit, or fraud, as the case may be. Now, in simple terms, sex without consent amounts to rape. However, the legal controversy begins when marriage is introduced into the discussion. Does marriage imply consent? Historically, the law answered this question in the affirmative. Under Old English common law, which significantly influenced Nigerian criminal law as well as most of other Commonwealth countries, there existed the doctrine of implied marital consent. Now, this doctrine assumed that once a woman consented to marriage, she gave irrevocable consent to sexual intercourse for the duration of the marriage. As a result, consent was presumed at all times. Now, refusal was largely irrelevant. Rape within marriage was not recognized. Now, this doctrine has found its way into Nigerian law. In fact, provisions such as Section 6 of the Criminal Code reinforces the assumption that sexual intercourse between a husband and wife is lawful. Now, for decades, Nigerian law, therefore, operated on the premise that a husband could not rape his wife. However, the law is not static. It evolves with societal values. Now, the VAP Act, a major legal shift as of today. In 2015, Nigeria enacted the Violence Against Persons Prohibition Act, commonly referred to as the VAP Act. This legislation fundamentally altered the legal conversation around sexual violence. Under Section 1 of the VAP Act, rape is defined as intentional penetration of the vagina, anus, or mouth of another person without consent. That's virtually all the body openings. The phrase another person is critical. The law does not exclude spouses. It does not recognize marriage as a defense. And the implication is clear. Under the VAP Act, a husband can be held criminally liable for raping his wife. Now, consent remains a requirement even within marriage. Now, forced sexual intercourse constitutes rape. The penalties under the Act are severe and may include life imprisonment, depending on the circumstances of the offense, of course. Now, this represents a decisive move away from the outdated doctrine of implied marital consent. Like, the implied means once you are married, the law presumes that there was consent, but there is a major shift now. Territorial limitation of this law. However, there is an important limitation that must be clearly understood. The VAP Act does not automatically apply across all states in Nigeria. Now, it applies to the Federal Capital Territory, Abuja. Also, there are some states that have domesticated or adopted this act. These states include Lagos, Oyo, Edo, states have not. Where a state has not domesticated this VAT tax, the applicable law remains the criminal code or the penal code as the case may be. But under which the recognition of marital rape remains legally uncertain. Therefore, the accurate legal position is this: a husband can rape his wife. Yes, a husband can rape his wife under the Nigerian law, but the answer depends on the jurisdiction where this act of course occurs. Practically, the realities and enforcement challenges of this law includes prosecutions for marital rape remain extremely rare. Several factors contribute to this reality. Cultural expectations. Of course, how can you take your husband to a police station? How can you report your husband at the police that your husband has raped you? This of course discourages reporting. Then lack of sensitivity or understanding among law enforcement officers. The fear of stigma, family pressure, or marital breakdown, as the case may be. Now, there's also evidential difficulties associated with proving rape as the case may be. There is often a significant gap between the law on paper and as it is in practice. Now, the conclusion to this is marriage does not amount to ownership. Marriage does not eliminate requirement for consent. Marriage does not provide immunity from criminal responsibility. The Nigerian law is gradually moving away from outdated assumptions, but inconsistencies remain across jurisdictions, of course. Until all states adopt modern legal frameworks, the protection available to victims will continue to depend largely on geography. Now, if you found this discussion informative, please like the video, subscribe to the channel, share it with law students, legal practitioners, and couples. Feel free to leave your comments and questions on the comment section. Also, watch our other videos, and remember, the fact that that person is your wife does not mean you can press her down